You are listening to Revealing Real Estate Podcast, where we dive into getting over your fear of taking risk in real estate and making money while you sleep. I'm Nico Pedizano, your host and real estate guru with over 20 years of experience. It's time to get real. The information on this podcast does not and is not intended to constitute as legal advice. Instead, all information, content, and materials available on this podcast are for general information purposes only. Information on this podcast may not constitute the most up-to-date legal or other information. All right. Well, it's really time to get real today. I am super excited to introduce this wonderful guest to our show. It's been long overdue. A lot of the things that I talk about on this podcast is all about real estate advice for sure. And I've talked many times in regards to the issues that we face with the Landlord and Tenant Board. And people understand how I feel about tenants right now taking advantage of the system that's currently, I feel, that is broken. So today I want to welcome to the show a paralegal from Silverline Paralegal Professional Corporation who specializes in small claim court litigation and residential landlord and tenant disputes. He has spent the last 25 years representing landlords. Please welcome to the show, Sam Ursino. Sam, welcome, and glad to have you on board.
Thanks, Nick. Nice to be here. Yeah, long overdue.
Long overdue, for sure.
Excited to be here. Hope we can get some good information out there.
Yeah, and I want to kind of just get, you're at the front lines of the current issues that landlords are facing. I know a lot of your representation is more in favor towards a landlord. And you represent a lot of landlords. And I want to understand, and I want to make our viewers understand who are listening to this show, the issues that we currently face when it comes to landlord and tenant disputes. And I'm hoping that we can get some insight on how a landlord today can understand that they need to do things the right way to expedite their applications through for the eviction process. And a lot of things, and the reason is because I believe that the current situation is just going to get worse as interest rates continue to rise, right? And these are a lot of the problems that we're going to be facing. What are some of the things that you are currently seeing today in regards to disputes between landlords and tenants?
Well, I think you hit the nail on the head with interest rates rising. I think it just takes the investor out of the game. And what we're seeing is a lot of small landlords who have investment properties, have put all their life savings in that investment property. They're now having to make a choice. Do I keep my primary residence? I can't afford both. So
right.
I have to get rid of one of them. And what we're seeing is a lot of calls coming in saying, I have to sell one of the properties. And which one can I sell? I have a tenant in one property and my primary residence I'm living in. So the choice there a lot of the times is let's sell the investment property, but the landlord then runs into issues. And I think the delays at the Landlord and Tenant Board are part of the cause of that. For a landlord to sell their investment property, they have to work with the tenant. They serve the required notices. They could do everything right and still be in a situation where they don't get vacant possession by the time their closing date comes around. I mean, what's an average closing date on a real estate?
Yeah, which is 60 days to between 60 to 120 days is the average closing date, right, for a transaction to take place. And then by the time we provide the notice to the tenant, and sometimes we feel like these tenants are really professional, that they agree that they're going to leave. We get the property sold. We have a firm date in place. And then all of a sudden they're saying, oh, well, I'm missing this, right? And they say, oh, I'm not leaving now. And all of a sudden they put their heels into the sand. And now we have to run through a very difficult, long process to start this eviction on them.
And so I see that all the time where a landlord is doing this in good faith. They think that, they spoke to the tenant's being very reasonable, cooperating. So they haven't taken the required steps, serving the required notice, starting the required application. Just taking somebody on their word is not the way to go in this day and age. You may get the odd tenant who will say, yes, I'm going to leave, and they do end up leaving. But the bottom line is when you have a real estate transaction that's closing, where you've promised vacant possession to a purchaser who's going to be moving in, let's say that's the key. Your purchaser has to be moving in for their own personal use, and they have to live there for at least 1 year. So if you have those circumstances, then you have to serve an N12 notice, right? And you have to do it right away, because your closing date, like you said, 60 to 120 days is not going to get you a hearing at the Landlord and Tenant Board. You're not going to have a hearing for 5, 6, 7, 8 months.
That's crazy though, Sam. Yeah. Right? If you think about how long it takes to even just to get a hearing, is ridiculous in my opinion, right? And I want to come on the record by saying that it should not take that amount of time to have that hearing in front of the board. And today I'm finding that there are a lot of tenants taking advantage of that, and they're looking for cash in lieu, right? You give me cash, I'll leave. Why should a landlord have to be in a situation where they're obligated to give somebody some cash so that they can take possession back of their property that they've worked really hard for? There's a lot of hard work, sweat and tears that have been put into that property. There's a lot of risk involved. And when markets do fluctuate, those are part of the risk that they're taking. And right now, as we can see interest rates starting to rise, there's a lot of people that are scrambling that are in the red, that it's costing them money every month that they can't afford. Plus, they have their current mortgage with the cost of goods going up within the market itself through our economy. Things are, I feel, will make landlords sometimes go rogue. And we've talked about this a little bit from that perspective. And there are things that people are going to be put in positions to do, things that they don't really want to do, but have no choice to do. So I just want to kind of touch base on that a bit, right? And these are very touchy situations right now within these moments.
It is. And, that's that term, cash for keys. I mean, you
Yes.
hear that all the time now. Like we'll have scenarios where tenants will call. We've served an N12 notice. The landlord has paid the required compensation that's required under the legislation. And the tenant will say, well, but I'll agree to leave. Let's do a cash for keys deal. And they're raising it to us as a scenario. And we've had situations where landlords have had closing dates that are fast approaching, and they've had no choice but to pay the tenant to vacate. And, it could be anywhere from a couple months rent to $20,000, $25,000. It really depends on the scenario, because you have a seller, landlord, who's looking at it saying, I have provided in my agreement of purchase sale vacant possession. I've agreed to that. And now I can't get the tenant out. And now I have liability on both ends. I have a tenant that wants money from me. But what's the downside? If I don't give this money to the tenant, I may be sued by the purchaser because I haven't been able to give vacant possession. And my liability might be a lot higher on that end. And so that's where you're facing. I agree with you. When you have a landlord that's done everything right and has paid the required compensation, the legislation has come forward and said it's a no-fault application, right? The tenant hasn't done anything wrong. They're just living there, but it's also the owner. It's their home, and they should have the right to choose what they do with their home. And in this particular case, they chose to sell it, or they chose to move into it, whatever the scenario is. But now they're being told not only, or they're being forced. They're not being told. They're being forced. Not only do you have to pay the 1 month's compensation that's required, but you may have to pay more. And so if you look at that as an investor, you deal with investors all the time. You've invested all your money to try and get ahead in this life. And all of a sudden, anything that you've earned over the last number of years, you're having to give back. And it just doesn't seem right.
It doesn't. And a lot of times I see some really big horror stories where the tenants are going in there after the fact and damaging the entire place. And I just feel sorry for a lot of people that are going to be struggling through this process to try to do that. And I want to clarify this too, Sam, and maybe you can shed some light on this. If I'm a real estate agent, right, and I put a property up for sale and I sell it to a prospective buyer, that prospective buyer, to get vacant possession, correct me if I'm wrong here, we have the buyer would need to move into the place. They can't buy it as an investment. If they are buying it as an investment, they have to assume the tenant that's currently inside the dwelling?
Absolutely correct. Yeah, 100%.
Okay.
The only way that a tenant has to vacate is if the buyer is intending to move in and is intending to live there for at least 1 year. It has to be a good faith application. the investor, the covenants run with the land. The tenant is part of that. And if you have a lease agreement, whether it's in writing or a month-to-month tenancy, it runs with the land. And the new purchaser assumes that tenant, and that tenant gets to stay.
At the current rent that he's paying. You cannot even renegotiate that rent. You only can go unless it's after 2018, 2018 or newer, correct?
So you're talking about the rent guidelines.
The rent guidelines, right?
Yeah.
Yes.
So you're governed by the rent guideline, and I think they think they've just announced next year's rent guideline is going to stay the same as this year's. And if there is an exemption, and that is of 2018, November of 2018, right, if it was a property that wasn't used for residential purposes. I've been getting some calls on this where people say, well, it wasn't rented before then, but that's not the criteria.
Right.
Right. Yeah. So you're talking about properties. An easy example is it was just built. You have a condo building that was just built and it was a new property. It's never been occupied before. Then you might fall within the exemption. Other than that, the guideline rent increase applies, and you can only raise it that amount. I mean, that's the other issue. And it's not a tenant's fault. Like, for example, a tenant's been in the unit for 10, 15 years. Their rent may not have been increased every year, or even if it was increased, it's a low amount. And compared to what the rents are today, it's a lot cheaper, right? And that's where I think a lot of tenants get their backs up, because they think that landlords are trying to evict them just because they want to get more rent. And that's not always the case.
Correct. Yes, I agree.
I think that, as inflation rises, the rental guideline increase has not kept up.
It hasn't kept up, and if we look at the amount of interest that the Bank of Canada now has introduced to the market, and when your variable rate is now running at 7%, and before you were at a break even, maybe you were making a little bit of money every month, a couple $100 every month as a landlord. That landlord today is now in the negative cash flow, and sometimes their mortgage payment is almost double from what they originally had. And I just think it's a little bullshit, in my perspective, Sam, that you won't be able to at least get what it's costing you, on that mortgage payment every single month from a tenant. And I think I think the system is broken. And I'm going to go on record for saying this, and I may get some slack for this, but the truth of the matter is I see both perspectives. I see both sides. And what I'm finding today, based on new legislation that currently exists with the LTB, is that people really do their homework nowadays. And they understand exactly what's in favor to them and what's not in favor to them. And I had a scenario where I ended up selling a property for one of my clients, and the tenant didn't want to leave. They knew it was going to take 7 to 8 months before they get a hearing in front of a judge. They knew that they were going to be able to get compensated very heavily for it, and did so that we could provide them vacant possession. I just feel that there has to be some sort of change that needs to exist and needs to take place.
I mean, I don't think you'll find anyone that disagrees with you. Clearly, hearing dates, that take 6, 7, 8, and 9 months to get, the system's not working. The system was meant to be an expedited system. It requires things to be done in a timely fashion. It affects both sides. Let's say it doesn't just affect landlords, because landlords are waiting for their applications, but tenants also wait for their applications. They may have issues in their property that need to be remedied, and that
and I'm sure that happens, for sure. Absolutely. Yes, 100%.
But in terms of fixing the system, we've heard them announce that they're hiring more adjudicators, and I don't know, by the time they hire some, but then others leave, and I don't know how further ahead we are. COVID really, put us behind the 8 ball. You would think by now we'd be able to get back on track, but we're not there yet. In the old days, we used to serve an N12 notice, and we'd have a hearing date before the termination date, right? And that was before we were required to give compensation. Now, these N12 notices are very technical. You have to do everything correctly, because if you don't do everything correctly, then you're going to start over again. And can you imagine starting over after 8 months of waiting?
So
having to
so
start
if you
over
don't
again?
do everything correctly, then you have to resubmit your application again, and then wait another 7 to 8 months before you get a hearing, or does that get expedited? Can you just give us there's a couple twofold question here, Sam. What are some of the steps a landlord can take to make sure that things are done correctly, besides the fact of hiring a paralegal to advise them? One, and two, if they don't do things incorrectly, what's the process on that as well?
So I think you said people are doing their research, people understand. I think there's a lot of landlords that don't understand the process. They'll serve an N12. The N12s, they give 60 days notice because that's what they think they have to give. It's not 60 days notice. It's 60 days notice that falls at the end of the term. So if a lease runs from the first of a month, your termination date has to be the end date of a month. So for example, we're July 17th today.
Yes.
You're going to give a notice today to your tenant for own use. It would be September 30th that your termination date would be, right? It's
Right.
60 plus days. So you can't just look at the 60 days. So that's the number one error that people make, is they put the wrong termination date on their notice. Then they serve a notice, and you have to file your application within 30 days of that termination date. If you don't, you have to start over.
Jeez.
So that's the second thing. You also have to pay 1 month's compensation, 1 month's rent as compensation to the tenant.
That's part of the N12.
Part of the N12.
Yep.
It's a requirement. If you don't pay the compensation by the termination date, then your notice is fatally flawed, and it'll be dismissed when you get to a hearing. No questions asked. And when I say you pay it, it can, it doesn't mean that you give it to the tenant doesn't cash it, and therefore it's not paid. No, my opinion on that is, as long as I've made the effort to pay it, if you don't cash it, that's your issue, not mine. And we've had several of those scenarios where tenants don't deposit the compensation, but that's not going to stand up. So you pay the compensation by the termination date. A lot of landlords will say, well, why do I have to pay the compensation? That's the first question I get. Why do I have to pay a compensation? And I tell them, because that's a requirement under the legislation. Why do I have to pay it before the tenant vacates? What if they don't vacate? That you'll have to deal with at a hearing, but you have to pay it. So those are the two issues with respect to the N12 notice, the main issues. And then when you file your application, you're required to file a declaration with that application, or else the board, according to the legislation, should refuse your application. And sometimes the applications continue, they proceed, and then you'll get to a hearing. And if you haven't filed the required declaration with the required terminology in it, then your application could still get dismissed. And so when your application gets dismissed, what happens? Well, you have to serve a new N12. You have to serve a new notice, because you can't rely on your old one because your termination date has passed and more than 30 days have gone by. You have to serve a new 60-day notice to fall at the end of the term, and then you have to file your application again. And as far as expediting, the board has a procedure that you can request an expedited hearing to shorten the time for the hearing. Those are not granted frequently.
Very easily
They're
either.
not easily granted.
Yep.
You'd have to have some extreme circumstances in order for that to be granted. I would say more times than not, they're denied, and you just go through continue through the process. So those people have to understand, the Landlord and Tenant Board is very technical. The notices are very technical, and if you get anything wrong, you could be setting yourself back quite a bit.
Enjoying this episode? Subscribe to our channel and leave us a comment down below to let us know what you want to learn next. Make sure you're following our Instagram and TikTok to stay up to date on our new episodes every Friday.
It's great to set the record straight here, and really give some understanding towards the process of it all, and it is real, and that's why I wanted to have you on the show, because it's different when it comes from you, who's a paralegal, who's at the front lines, who deals with this stuff every single day. We talk about a lot of you didn't mention about declaration. Just for our listeners on it, a declaration would indicate, from a prospective buyer who's buying that property, that they're actually moving into the unit themselves with their family. That's the best way to actually start the process. Does it move things a lot quicker once the declaration is signed and provided to the tenant, or is the time frame still the same?
No, it's the time frame is going to be the same. It's a requirement. So what I would say from, getting into your realm, from an agent's perspective, you want in your agreement of purchase and sale, you want a clause that says that the buyer is going to provide that to you. Because if you don't, and then the buyer doesn't move in, then the tenant is going to come after you as their landlord, as a bad faith application, right?
Right.
So for example, you enter an agreement of purchase and sale, it gives vacant possession, and you had a verbal conversation. Yeah, we plan on moving in.
Mm-hmm.
Well, now you haven't made it a requirement on the buyer to provide you anything. They're not cooperating in any way unless you make it a requirement. And they can turn around at the end of the day and say, no, my agreement says you're giving me vacant possession. How you do that, that's not my issue.
That's not my issue.
Right. And we see scenarios where tenants do file bad faith applications because at the end of the day, the buyer didn't do what they promised they were going to do. And they go after the landlord. If the tenant moves out before the buyer becomes the landlord, their only option is to go after the old landlord. Now, in that particular scenario, you're looking at the time the N12 notice was it given in good faith? And as long as the seller has done everything, the landlord has done everything that they need to do, and that includes get that declaration. There's a clause in there. You have confirmation that the buyer is moving in. So when I give that N12 notice, I know I have everything I need that confirms the buyer's moving in. There's not really anything else I can do. If the buyer doesn't move in at the end of the day, that's kind of out of my control. I confirmed everything that I could. And then it's on the buyer. But I also think that as an agent, you may want to consider some sort of indemnity clause in your agreement of purchase and sale that says if you don't do what you say you're going to do and they come after us, you're going to indemnify us for any costs that we incur, or any damages that we incur as a result. So it just affects all kinds of different scenarios, everybody. It affects the agents that you're trying to sell a property, and you're jumping through hoops trying to do that.
Yeah, it's a lot of work. Sometimes when we're dealing with the tenants and rental properties, man, sometimes we don't even want to take them on when it become very nasty, or they become very because they're time consuming, right? And you're just dragged into that entire process, which sometimes becomes frustrating, because how many other things could you be doing, in the fact, but you can't leave people stranded. They need the help, they need the guidance. And that's why I refer somebody like yourself to go there and help out with the matter, just because it makes life so much easier from our perspective. And I've gone through this before where I've sold a property. I sell it where the buyer wants vacant possession. I don't get a declaration signed by mistake, right? I don't have a clause in there saying that, if the tenant doesn't move out, you still have to close in on the transaction. A lot of times, buyers want, once they demand vacant possession, they put a clause inside the agreement of purchase and sale that they want vacant possession. There's also a stipulation in there that if they don't get vacant possession, they can also extend the closing date of that contract as well. And that's what real estate agents should be doing on the buyer side. And then if you're on the seller side and you're representing the seller from that perspective, you got to make sure that, hey, listen, if I'll do whatever I can to get you vacant possession, but if I can't provide it on closing date, the onus falls on your shoulders. But then that's where you get that. Yeah,
it's a tricky
that
scenario.
Little bit. It's a tricky scenario.
I have one right now where the buyers want to close the deal, but they're still a tenant. And they want to move in, but the closing date's already been extended, and
they want the house.
They want the house, but they don't know whether they're going to get vacant possession, because you have to remember, it's an application, and it's an application that has to be made to the board. And until the board terminates the tenancy, there's no guarantee. There's something could happen, that there could be something that prevents the board from granting you termination. If it's a good faith application and presented properly and all the facts are in line and you've done everything necessary, you should get that termination of the tenancy. It might be delayed. The board has to weigh the prejudice to the landlord and the prejudice to the tenant in determining what that termination date should be. But nobody could ever guarantee you that it's 100% going to be terminated. And so if you're a buyer that's buying that property, if you assume the tenant, you may not get vacant possession. So that's a risk that you're taking. You have to determine what level is that risk. What's the percentage? I would say more times than not, if, like I said, everything's done correctly and it's a good faith application, you'll get your termination. You're a buyer that's moving in. You should get it. I don't see why you wouldn't get it, but there are some circumstances, and it may not be that you don't get it right out, but it might be that, it's extended. The termination date could be extended. Maybe the tenant has some issues that prevent them from moving for whatever reason. The board will look at all of that.
Right.
So as a buyer, you need to take your chance and decide whether that risk is one you want to take, or do you move on to the next property that doesn't have a tenant in it or that already has vacant possession.
Right.
So I think that we've talked about the N12. We've talked about we touched a little bit about bad faith application.
We're going to get into that a little bit. Yeah, that was next on my agenda.
Yeah, I think people need to be aware that you can't just serve a notice on a tenant just to get them out. Right, you got to do it in good faith, because the legislation it's tightening. It's tightened, and it's going to continue to tighten, because there is the fear that people are getting tenants out, landlords are getting tenants out because they just want to raise the rent. And tenants are in a situation where when they have to leave one property to go to another, their increased rent is considerably higher if they've been in that unit for a while. So, make sure that it's a good faith application. It's not the route to go. If it's not good faith, don't do this application. The tenant can bring a bad faith application against you after the fact. Just because you get an order from the board that says it was a good faith, they agree it's good faith at the time, circumstances could result, if you don't do what you said you're going to do, you could be facing a bad faith application, and the repercussions could be high. You could face fine to the board, abatements of rent. You could have to pay increased rent that the tenant is paying. You could just have to pay 1 year's worth of rent, period.
Unbelievable.
So, you talk $2,000. Let's say the rent's $2,000 a month. Tenant moves out. You don't move in. Tenant brings a bad faith application. 2 years worth of rent's $24,000.
Yeah.
1 year worth of rent, $24,000. It's a lot of money.
Yes.
And so, we just got to make sure that
landlords don't start going rogue and do things that they shouldn't be doing and go through the process as strenuous as it can be. Following the law is the best advice and going through the system itself. But, Sam, do you feel that the law is more in favor towards a tenant than it is a landlord?
Well, if you look at the purpose of the legislation is to protect, for the most part, it's to protect the rights of the tenant.
Correct. And it wasn't always like that.
Listen, you're going to have people that represent tenants on a regular basis. They're going to give
you a whole different opinion on this.
Completely. They see it from their side, and it's the legislation is in favor of the landlords. They're going to say, do I agree with that position? No, I don't agree with that position. I think that, there needs to be improvements. Maybe there can be improvements to help both sides, but there certainly needs to be improvements. And the number one improvement is the delay. The delay needs to come out of the system, because it's just created a situation where you're pushing people to the extreme, and that's the problem.
Correct. And that's my biggest concern, is how far would somebody go on a bad faith application, because at the end of the day, the one way or another, they're either going to lose the house, go to foreclosure, but and deal with those consequences, or go with a bad faith application and say, okay, well, now, Mr. Tenant, you take me to the board, and we'll deal with that after the fact. When we go, and I just want to talk a little bit about bad faith applications, Sam. What are some of the stories out there that you've seen that you can maybe share and put some light on when it comes to a bad faith application? What have you seen out there?
Well, I think in terms of the bad faith applications that we've dealt with, there are applications that are filed all the time. Tenants file the bad faith application. But what we need to understand is it's just because a landlord doesn't move into the property or didn't stay as long as they said they were going to stay, that doesn't necessarily mean it's bad faith. Now, the onus is on the tenant, right? There's a reverse onus. Usually as a party who's suing, who started an action, the onus is on you to prove your case. But in a bad faith application, there's actually a reverse onus. You're automatically deemed as a landlord it's deemed to be a bad faith application if you don't move in or you don't stay there for the 1 year.
Right.
It's a reverse. You have to prove that it wasn't bad faith. So the onus is on you to prove that. And so there are scenarios where circumstances have legitimately changed. And at the time you gave the N12 notice, it was absolutely a valid notice. And the intention was good. I mean, I can give you one example. I had an elderly gentleman, his family and him decided, his mobility was affected and he was going to move into a condo that he had. It was currently rented. They served an N12. The tenant vacated pursuant to the N12. And the landlord then came down, was diagnosed with cancer. And although they had started prepping the condo for him, he could never move in and quite sadly did pass away actually prior to this case getting to the board. But the tenant filed a bad faith application saying, you didn't move in. He didn't move in. And that's what he said he was going to do. So we had to fight an application that showed that at the time we gave the notice, it was given in good faith, but there was all these circumstances with the health and that prevented him from moving in.
Right.
And in that scenario, the board did dismiss the tenant's application. But, I've had scenarios where, again, dealing with real estate, I've had scenarios where, there was a deal, an agreement of purchase and sale entered into, purchaser backs out. An N12 had already been served. Purchaser couldn't close the deal. The day that the landlord found out that the deal couldn't close, they contact the tenant. Tenant says, I've already found a place, and moved out, and then brought a bad faith application.
Wow.
We went to a hearing on it.
Yeah.
And at the hearing, the tenant was awarded a judgment, and we were required to review and appeal that
Unbelievable.
decision.
How does that even make any sense, though? Right? What fault is that of the seller, in my opinion?
At the end of the day, we won on our review.
Oh,
on our appeal. And but the bottom line is, those are all things you may have to deal with. And it was the wrong decision the first time, but it was corrected. But look at the time, the money that was spent dealing with it. So, bad faith applications, just you may still have to deal with a tenant coming after you. They think you didn't do everything right. But as long as you've done everything right and you cross your T's, dot your I's, then you should be okay.
Got it. I wanna go on to non-payment of rent or late payment of rent. What is the form? What's the form called on that one? That's an N4. So on an N4 for non-payment of rent or late payment of rent, there's tenants out there right now that really, and we call them professional tenants. They're gonna come in with the best applications. Their credits are phenomenal, and I hear about it, and they jump from house to house to house, abusing the system quite often. And this is something I just want to kind of put some light on. It does happen. And sometimes what they'll do is they'll go in, they'll rent a property, they'll give their first and last, and then after that they're not making any further other payments after that. And now you have a landlord who's struggling to follow up and make those payments, of course, to their mortgage agent. And now to go get an application into the board, it can take 7 or 8 months. But these guys now have run and lived inside this property for up to 12 months. If you've done things correctly, it can take you between 8 and I think even sometimes longer. Can you put some incitement on that?
Yeah, you're absolutely right. It does happen. I've seen it happen many times, first and last and nothing else.
And nothing else after. Yep.
But so the issue here is what the landlord has to take away from there is, and I'm going to distinguish between the non-payment and the late payment because
yes,
they're two
please.
different applications,
Yes.
right? So the non-payment of rent is avoidable. It's avoidable notice. So once you serve that notice, if the tenant pays, they get to stay, right? If you go to a hearing and you get an order terminating the tenancy, it'll have a new termination date in that order. And if the tenant pays by that date, they'll be allowed to stay. But what you're talking about is a scenario where the tenant's just racking up the arrears.
Yeah, and I want to talk about both scenarios, really, right? Because they're I'm sure there's a lot of people facing both scenarios here right now that are listening to the show. So you got one where the professional tenant, they're not paying their rent at all, and then sometimes they're late in payment. But I wanted to ask you, what should a landlord do within that process first? So let's talk about the first scenario.
So I think what we have, because the delays are what they are, and the non-payment of rents, you're still talking 5-6 months to get a hearing date. And so my recommendation is you got to act quickly, right? You can't wait. Like we used to have landlords that would wait a couple of months before they start an application or a notice, serve a notice.
Yeah.
And you can't do that anymore because you're just going to put yourself behind the 8 ball. So serve your notice, right away when you're allowed to file based on your termination date, file your application. But one mistake that landlords make is the legislation did change a little, and it requires a landlord to make an effort to try and reach a payment plan with the tenant. So when you serve that N4, you need to reach out to your tenant. You need to ask them, let me know how we can, come up with a payment
And put
plan
things
on
in
this.
writing.
Everything needs to
Put
be
things in writing, not verbally.
Yeah, absolutely. I mean, the requirement from the legislation doesn't necessarily specify it has to be in writing, but you should, to protect yourself, make everything in writing. Because the board, believe it or not, the adjudicator could deny your arrears application or could deny you your eviction if you haven't made that effort. The legislation allows that.
Right.
So that's important that people understand they do need to try and work with the tenant to come up with a payment plan. And you're going to have some tenants that are just either going to not, a lot of times they don't respond or they make promises and don't stand by those promises. You just take note of that. And when the time comes for hearing, you gotta mention that. So the process, you file your notice and then you file your application, you get in front of you get to a hearing. You're going to have the option when you get to a hearing. You're going to have a mediator. The board supplies mediators that can help you reach a resolution with the tenant. And your last resort is attending before the adjudicator. Now, most of these arrears hearings are in half-day blocks. So they do a morning block and an afternoon block, and there's a number of files on each block. And the board will deal with unopposed matters. They'll deal with consent matters first. And that's where the landlord and tenant have reached an agreement and they've worked it out, and the adjudicator will issue an order on consent. Then they'll deal with unopposed matters. The tenant or usually it's the tenant on an arrears app didn't show up, and they'll deal with that application. And then they'll deal with all the opposed matters. So when it comes to an opposed matter, remember your block, the hearing starts, you sign in at 8:30, hearing starts at 9:15, after they do their preamble, it's going to end at 12. So if you get close to that time and it's an opposed matter, you may be pushed to another date. And the new date may not be the same length of time to get to, but there'll still be some time in between there. It won't be right away. It won't be the next day. It won't be the next week. Right. So you're going to have, a month, 2 months, maybe even more, that you're waiting for another hearing date, and arrears are accumulating again. I mean, in the old days, in my perspective, when I have those hearings, I ask that an order be issued to require the tenant to pay the rent moving forward, at least, right? And there's, you get mixed results, depends on who's sitting, but you have to try and deal with it. My recommendation is if you can come to a resolution with your tenant, there are things that you can put into an agreement that if a tenant breaches that agreement, that you can then apply to the board without notice. It's called Section 78 of the Act. And it allows you to get a termination of the tenancy.
And I, as an agent, can add a clause inside the agreement for that?
No.
Or it has to be signed separately?
This is what I'm talking about now is an order that's issued by the board.
Right.
Would have what they call a Section 78, which
the
tenant is agreeing to make all the payments and they agree to pay the amounts on time and in full. And if they don't, then the landlord can apply to have an eviction take place. So this is after you've attended, you filed your application, you attend at the board, you reach an agreement. Because some people, landlords will look at it and say, well, how do I know? The tenants lied to me in the past. They're not going to make their payments. Well, this is your protection, right? You've got a clause in there that allows you to enforce what you're signing. So that's the N4. That's your basic N4. As far as the persistently late, the tenant's always late paying the rent, but does end up paying it. There's a form that you can serve. It's a persistently late paying the rent. I would say for the most part, you have to understand the board doesn't want to terminate tenancies. That's not they don't like to do it. So if tenancy can be saved, they'd like to save the tenancy. So on a persistently late paying the rent, what they'll normally look at is try and find a scenario where maybe the tenant can agree for the next year to pay their rent on time. And if the tenant can pay the rent on time, great, everybody's happy. But if the tenant misses one of those dates, then the landlord has the right to apply for an eviction,
Right.
Termination of the tenancy. So, I mean, those are little things that, you may not know as a landlord. If you hire somebody that is in the system and knows what they're doing, then they can help you with that. And I think that because of the delays that we're facing, it's more important now than ever to make sure that everything that you do, you know what you're doing and you do it correctly.
Very true. Very true. And if you don't know, hire somebody that knows, hire a professional to do their job. If you have somebody who's in non-payment of rent and you file them and you go in front of a judge and you win, is there anything that a landlord can do to go get compensated for the losses that he's occurred over the time frame, and go back to try to get compensated from that tenant who's in the rears?
Yeah. So you have an order. You've won at the board.
You won at the board.
You got your order. That order will be both a termination of the tenancy as well as an order for payment of the arrears of rent. You then need to take that order and you can file it with the small claims court and try and enforce it through the small claims court in any way that a normal judgment would be enforced. You can garnish wages, you can garnish bank accounts, you can, put writs of seizure and sale of land if the tenant happens to own property, which is not normally the case, or, personal possessions. Normally the basic two ways are garnish of wages or bank accounts, right? So there is a way to do it. And, we do that all the time. That's a big part of our business as well. It's, you got to be patient. You have to be patient.
You have to be patient, for sure.
And, you have to also understand it's important, when it comes to that part, the end part is collecting. But what ends up happening is what you did at the beginning of that tenancy is really what's important. What information did you get? Do you have identification? Do you have all the proper details? Did you do your checks on your tenant before you rented it to them? Everything you did at the beginning of that is going to help you in the end.
100%. And when we rent out properties, even through our team, we thoroughly go through every single aspect of that particular client. Reference letters, employment letters. We call their employers. We call their previous landlords. We find financially if they can't afford to even make that payment, because based on their T4s, you can ask for a copy of their T4s. I want to know, Sam, too, as well. I want to know if somebody's a criminal, right? Can I ask for a criminal background check?
I don't. I've never had landlords ask for criminal background checks.
Is it something that is bad to ask for?
I don't think that as a landlord that you'd be able to make that as a requirement.
You can, yeah, okay, yeah. Just wondering, just curious out there, because I a lot of times you get on different boards, they want a criminal check. They want to know the history if you have any criminal background too as well. Yeah. But I guess it could be something very.
Yeah, we're also dealing with human rights, right? You're dealing.
True.
There's only one legislation that takes precedence over the Residential Tenancies Act, and that's a human rights.
That's a Human Rights Act. Yeah, I got it.
Yeah. So.
But good to clarify, though, right?
Yeah, you need to be careful on what you can't. You got to make sure that you're not, discriminating or against somebody. Be very careful on what you do.
Well, the point of it, though, is just making sure that we do thorough background checks on that tenant to verify that their foregoing application is valid and that they haven't done this in the past. And if somebody's renting, most likely they have a previous landlord. And I there's a lot of people that try to save that 1 month's rent that they're going to pay a realtor, and it doesn't make any sense from my perspective, because everything gets done collectively from our end to make sure that we're doing everything within our capabilities, that we're not going to provide you a delinquent tenant. It's the same thing if I now have a tenant who is a delinquent or is not paying their rent or is providing some issues. I'm not going to go to the board myself. I'm going to hire a professional like yourself to guide me through the process and do what you do as a professional. If I'm not a landscaper, I'm not going to do my own landscaping. And it's just kind of my motto is hire a professional to do what a professional does. And I think, Sam, you come highly recommended. You are a wonderful advisor to myself and to our team. You've represented many clients for ourselves, and we will continue to build on that as well. If somebody is going through some issues right now, Sam, within their life, and they're dealing with these tenant LTB issues that we face right now currently in the market, how can somebody reach you?
Yeah, absolutely. You can go onto our website, silverlineparalegal.com. You can reach me. Our phone number, contact info is on the website. Absolutely, we'd be happy to assist.
If you want Sam's information, guys, just DM me. You'll see me on Instagram. You can get a hold of me. The OP team, we're pretty easy to find as well. So just send me a message, and I'd be glad to share on Sam's information. And we'll definitely look forward to getting you back on the show sooner rather than later, because there's still lots to talk about, Sam. But it was a pleasure to have you on the show, and thank you for coming in.
All right, it was my pleasure. Thanks a lot.
Looking to buy or sell? Call a team you can trust. Don't believe me? Our Google reviews say it all. Put us on your lawn, your house will be gone. TheOPteam.com.